Greetings everyone. I Khushbu Chawla from Team Legal Vidya welcome you all to 28th class of the 9-week certificate course on advanced legal drafting by Team Legal Vidya. Now, I would like to welcome our honorable speaker of this course, Ms. Shivani Gupta, to take the session forward. Welcome, ma'am.
Good evening, Khushbu. Good evening, Legal Vidya. And good evening, all the participants present in the session. A very warm welcome to the today's session. We're just sharing the PDF. By the way, I have shared the two PDFs in the WhatsApp group. I hope you guys have downloaded them and you received both the PDFs. The PDFs are all about the today's session, what the today's session says so, and what is the validity for the today's session. I think everyone has received the PDF. Okay, wait, I'm just sharing the screen. The screen is visible to you all. Please give the thumbs up. Okay, okay, okay. Yes, so today's session we will also discuss about the another provisions of the Arbitration and the Conciliation Act. Is same as earlier we have discussed about the how the arbitrators are being appointed, what is the process, or how to initiate the arbitration proceedings, how to just arbitral what are the provisions against the challenging appeal provisions of the arbitral awards, how we appoint the arbitrators, and how just the parties being agreeing about that they just are looking forward their dispute to settle via the arbitration procedure and so on. So these are the basic things that we discuss about till now. Now in the today's session we're gonna discuss about one more provision, and that provision is about the section number 31. Actually, today I have shared the two PDFs of the section number 31. In the previous one, it's about the PDF that is being sharing upon your screen. It's about what are the provisions there. Okay. And in the next PDF, I have shared about the latest judgment on the same of the Delhi High Court. So don't get confused. Actually, the PDF that is being displayed on your screen, please go through the same. That is about section number 31. And now I am just scrolling down just so that you can be acquainted with what is the aspect of the section number 31. Say so. Yes. Should we start the session with the provision aspect? Please give a thumbs up if the section number 31 text is visible to you all. Okay, okay. Now, just moving ahead, just move directly jumping into the provision of the section number 31. We have to just look a little bit about the history. We will just went into the history of year 2014. It's the month of the August only, when the law commission has submitted the report number 246, and the Indian Law Commission that just submitted the report, and they just is like recognizing one of the complications, we can say, yes, the complication word is absolutely right, that is associated with the arbitration. Now a question will come into your mind that what can be the complication associated with the arbitration. So yes, there was a particular thing called for the kind of a hefty fees that being charged by the arbitrator. And we already know that the arbitration is just like a expeditious, it's just like a fair, simple, cost effective ADR to the litigation. But over the time, ADR also become very expensive. And then there was another report. As the same report was just like on the behalf of those recommendations, there was an amendment being made under the 2015 Act. So that before directly jumping into the section, we have to put these things in our mind that under the section number 31, subsection number 8, the provisions were made, and the provisions were will okay will let you make you check the provisions also. It's under the subsection number 8 only. There was a provision that is being inserted. Okay, now it being inserted with the accordance of section number 31A. Mention it like this only. Now the amendment that are being wait for a second. The amendments that are being dealing with or that are being add on to the provision was just to, dealing with all the complications that were arising in the case, especially in the case of the arbitration. And that amendment were made, major amendment was made in the year 2015. Moreover, dear participants, there is no as such draft to present today. Today we have to discuss about the section number 31 of the act only. So please don't get confused. And it's a very important provision. When you are learning the drafting related to the arbitration, you have to keep in mind this provision also. So don't get bothered, and it's as per the schedule. Now, we will discuss into what's the amendment being made to you all. I hope my voice is all clear to you. Yes, then the section number 31A, okay, Anamika, the section number 31A that is being particularly deal with the complication, and that complication is just like cost to be awarded in relation to the arbitral proceedings, or we can also say the court proceeding. But the recommendation of the law commission was just like the loser pays rule. And the loser pay rule means that the it can be justified on certain grounds also. For example, that is providing economically efficient deterrence against the frivolous conduct, and also with the further compliances with the contractual obligations. So this is like we are justifying that the let the loser who has to pay the rules. But the intention of the legislation was particularly to discourage the frivolous conduct, the dilatory practice against the awards that are being thrown on the awards on the court. So there were, it's just like for the cost allocation, three rules were there that were followed. So on in the 2015 amendment. That is loser pays, either the loser pay means that is also known as the English rule. If anybody have studied about the arbitration act, then they must have read this, that's the English rule. Now next is like pay your own way. For example, this is also called the American rule. And the third is very important. That is the pro rata. That pro rata means the appointment, kind of apportionment of the cost or the proportional allocation. So these are the amendments that are being uh, uh, we can say made after the recommendation of the Law Commission of India. But there are certain problems that those need to be addressed regarding the law of cost, and the certain amendments at that time those were made just to sort to overcome, and it's also to identify and just to characterize whether arbitral tribunals or the courts justifiably allocating cost in the arbitral proceeding. Now you would be just like, why I am reciting all these things? So because this is not mentioned in the section. Because dear participants, the section and the law you can study by yourself. But you have to be just one thing must be clear in your mind. For example, like what the provision is saying. So what are the amendments being made? Now we will jump into the text of the same. The text is visible to you all. Text says so. Forms and contents of the arbitral award. But today's session is more about the cost allocation. So we will discuss about the cost allocation also. But before that, I will give a reading to the provision also. Section number 31, Arbitration and the Conciliation Act, its form and the contents of the arbitral award, where subsection number 1 says so, if any kind of arbitral award shall be made in writing and shall be signed by the members of the tribunal. Simple thing is this, that it would be undersigned. The purpose of the subsection number 1, in the arbitral proceedings, more than one arbitral, the signature of the majority of all the members of the arbitral tribunal shall be sufficient, so long as the reason for any signature is omitted signature is stated. Okay, the second is this. The subsection number 3 is award shall state the reason upon which it is passed or it is being based. Okay, unless the parties have agreed, no reason to be given. The award is an arbitral award agreed under the terms that are being mentioned under the section number 30. Now there are other provisions also. The award shall state its date and the place of arbitration as the determined in accordance with the section number 20, and the award shall deem to have made at that place. The section is clear. I hope the clear is to you all. Next, the signed copy will be delivered. For example, the judgment copy is being delivered or the order copy is being delivered to the disputed party. Same as that. Arbitral tribunal may time during the arbitral proceedings make interim awards. Provisions for the interim awards are also there. Now there is another subsection, clause A, unless otherwise agreed by the parties, where and insofar as the arbitral tribunal is for the payment of money, the arbitral tribunal may include in the sum for which award is made interest at such rate as it deems reasonable on the whole or any part of the money for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. Next subsection says so about that sum directed to be paid, but you have to keep in one mind these were sets of two provisions that were always remain doubtful. That's why the amendments were being made. Then the sum directed to be paid regarding the arbitral award shall be unless otherwise the arbitral directs carry interest at the rate of 2%. Now the expression current rate of interest shall be included therein. And there are certain provisions are being made, amendment are being made to the subsection A. So this is what the section number 31 text say so. Now in the other part of the PDF only I have mentioned that how if the question comes in your viva, then how you will prepare. It's already saying section number 31 is just like for the requirements and the contents of the arbitral awards or award written award must be written, award must be undersigned by all the arbitrators present there. Majority of the arbitrators, single signed copy will be delivered to both of the each of the party, for example. And regarding the payment of the money, interest rate shall be 2% higher than the current interest rate, and so on. But in today's session it's just not enough to discuss about what are the particularly section number 31 says so. But it's when we discuss about the section number 31, we have to be more focused upon the subsections and the section number 31, subsection number 8, what are the provisions, what are the salient features. Because when we discuss about the provisions, then there are two things like there are first the provisions were for pre amendment position was there regarding the cost allocation. And when in the 2015, as I told you earlier, the amendments were made, then the post amendment position regarding the cost allocation under the section number 31 we need to study. Now when we discuss about the pre amendment position, then it was just like there if there is anything like absence of any agreement to the contrary, then what would happen? Then in that case the section number 31 subsection number 8 clause A will just like simply imposing any kind of a duty on the arbitral tribunal to fix the cost of arbitration. So I think these are the certain things you also be like, okay, these are the very wrong things. Now another is just that another provision is just like mandating tribunal to specify the parties also to entitle to cost. The party shall pay the cost or the quantum or the method of determination of amount and in which way it will be paid. So this is also a wrong thing. And these are the things what I am discussing right now are about the pre-amendment position, and regarding the cost allocation. And after these lacuna, only the amendments were proposed. The suggestions were given. Report was submitted by the law commission. Now another thing is also is that the section number 31 subsection number 8 contains that explanatory cost, for example defining cost, qualified cost, and those cost and the qualified cost are just like the reasonable cost, and they were still subsidizing. So these were certain things that actually the main motto or the main object behind the section number 31 subsection number 8 of the Arbitration and the Conciliation Act was. Okay, can anyone tell me here what with the particularly why there is a need to enforce the Arbitration and the Conciliation Act? First of all, tell me this. If you are acquainted with why there is a need to just to bring the bill of the Arbitration and the Conciliation, why there is a need to enact the law, why there is a and moreover why there is a need for the section number 31. Yes, please, anyone would like to at least make a attempt? You can unmute also to save time. Okay, okay, in general you can say just to save the time. The arbitration processes were the methods to adopt your dispute redressal. Yes, anyone else? Even the Viva only, ADR Viva is there in the BLLB and LLB, and your examiner asks why they enacted the law. Then you can simply say that to settle the disputes outside the court, settle the dispute in a very particular time period, and it's a cost-effective process. That's why. Now, you can say these things or not. Either say yes or no. Okay, Anamika is there. She's saying yes. Okay. Now I ask you one more thing, that why there is a need to just enact the provision of section number 31 subsection number 8. So it was just the provision that is dealing with the cost in the arbitration. So when there is a provision, it means that what? It means that it's a default rule, and a default rule means that default rule saying so what? It means that uh, we can say the parties could contract around and it's the manner in which they deemed choose, and however in the absence and of any agreement regarding the cost, it's a duty of the arbitral tribunal to fix that cost. But now we discuss about the practical aspect. But in the practical aspect, it's just like arbitral tribunal are never been in just like a position to exercise their duty in allocating costs in the manner just we can say conductive to prevent any kind of a frivolous conduct of the parties. And there is another problem also. And another problem with the regime was that on the cost was that there was no as such clarity there. There was no as such clarity regarding awarding the cost and related to the court proceedings, related to the arbitration, so on. So we can also conclude one thing, that the arbitral tribunal were also not empowered enough, and they were just like, for example, under Article number 136 of the Constitution says about. Is there any provision under Article number 136? Stop Googling. I think you have studied in the class the Constitution of India. Special appeal. Yes, anyone else? Good going, Anamika. Only Anamika is just learning here. So yes, good Anamika. There are certain being appeals provision is there under the article number 136. I think every student have read the article number 136. In the administrative law also we studied it somewhere. So regarding that, the first of all I said what arbitral tribunal are not empowered. to award any pre-arbitration cost and so on. And article number 136 also uh, of the Constitution of India, that is just like a appeal from the order of the designated persons, that is regarding the pre-arbitration proceeding. So if once you just keep one thing in your mind, that the court doesn't award in such proceedings, then what would happen? Then the amendment must be there just to empower the courts, all the courts in the country, to award the cost and to reasonably compensating the winning party in all the arbitration related proceeding. So the this kind of a dissatisfactory state of law, and that is the application that is being lead to a new reform. Now we will directly jump to the recommendation. First of all, recommendation were just like under the 2046 Law Commission report. It was just like they said only you have to amend article number, sorry, section number 31, subsection number 8. They simply said it this. They said what? They said that there is a rebuttal presumption, and for example, there is a need for the treatment in the cost as compared to the traditional litigation. So, commission was just like recommending for the two reasons, and the two reasons were first of all, the reason was the loser pay principle, that is already providing the indemnity to the winning party. What is the meaning of indemnity? We can say here, anyone, please? Next is just like to punish the losing party who frivolously drags down the party to court, or just who frivolously dragging down the parties to the arbitration, or just like we can say who is just setting up the inequitable arguments to avoid the compensating the winning party for the losses incurred in resolving any dispute. Now, this was the stage till 2015 when there were no as such disputes redressed, issues redressed, and the things were not clear at all. Part of the contract where the party, when the third party gives compensation to the other party. Okay, Anamika, good going, girl. Now we jump into the one another aspect, that is now amendments are being made. Only Anamika is there who is just responding to what I am asking. I think she is the one who is listening carefully. Good going, beta. Now, the thing is post amendment position. So now amendment recommendations were just followed up by the government. The parliament made the amendments, and the amendments were what? Amendments were saying that section number 31, subsection number 8, there were certain amendments made, and those amendments, first of all, they are doing what? They are just empowering the court or the tribunal to award the cost in the proceedings under the Arbitration and Conciliation Act. Now they have the discretion, particularly to determine certain factors, and what those factors could be is that the cost are, when the costs are to be paid, what is the amount of the cost, where the cost, whether the cost are payable at one party to another, or what. Now that another thing is that the losing party, but now there are two rules that are also being stated, and those rules are like a losing party should be ordered to pay the cost of the to the party of the party who has just won the case. The court or the tribunal has to make a speaking order also regarding for departing from the general rule divided. Now, another is that the provision about the subsection number 3, I think, is just the there must be the circumstances also to determine the cost of sale. After the 2015 amendment, actually, the then those that amendment also empowering the High Court. Actually, I didn't remember one case law of the same. So case law Chandrasekhar, like case law is there, that is having empowering the High Court also to make any kind of a rules also for determining the fees of the tribunal and the manner of any kinds of his payment. Now there are certain things that ambiguities arises in the 2015 and the 2019 amendments. Now what happened? Because ambiguity arise, and it was a big debate at those time. Why? Because the 19 Amendment Act was just substituted section number 11, section number 14, and that was inserted by the 2015 amendment. So the provision was reduced also. Now, there is even case law also. That case law name is National Highway Authority of India versus the Gayatri Jhansi Roadways. That is the Gayatri Roadways also name is there. That is Gayatri Roadways Limited, and that is what in this case it was held that Honorable High Court of Delhi only it was held that the arbitral tribunal is all just empowered to fix its fees on its discretion, but this thing can be only possible of in the cases of ad hoc domestic arbitrations. But now another judgment of the Delhi High Court came in another case, that is the National Highway Authorities versus the Gammon Engineering case, that is the Gammon Engineering Services Private Limited. Then the cost was not particularly defined, so now the cost was also particularly defined, and it was just like cost are like just the awarded by the arbitral tribunal, part of its favor award in the favor of winning party and against the losing party. And there was the omission of words. The words exactly were I didn't remember, but the words were I think it's like unless otherwise, and those of agreed by both parties. I think these are the words only. I didn't remember the sequence, but those words and those words were removed. Now what happened, under the year 2019 Supreme Court also overruled the High Court judgment, and a High Court judgment of the Gayatri Roadways case. And now what happened, the Supreme Court upheld that the what the court says in the Gaman case. The court said that the related to the interpretation of the section number 31A and the section number 31 subsection A. Now we can say that rather than rallying upon the 2015 amendment, new amendment under 2019 also, there was an objective being promoted, and objective is just like to promote the institutional arbitration, means that it is just kind of providing some of the solutions. But when it comes to the ad hoc, where there is no as such interference by the court, there are arbitral institutions, there are parties, and in most of the cases that's like do not pre-decided the fees of the arbitrator. So when these circumstances arises, the question remains is whether the fourth schedule is applicable or not. So if so, then it is mandatory or directory in nature. So under the 2019 amendments, particularly, High Court is just like now empowered, and it's just like now expected to designate arbitral institutes to discharge all the proper and the necessary functions, and that will also include the appointing arbitral tribunal and determining the fees of the arbitrators. For a second, yes. Now, but however, the one thing will definitely come into your mind. Does this all the amendments are just like ambiguity is leaving or not? Achha, okay, you tell me. Is there anything that is being the ambiguity left? Yes, anyone? Either say yes or no. If you think so, the ambiguity left, then please say yes. And if you say no, then it's okay. Then also put forth the reason. No one is just gonna tell me. Okay, no worries. Yes, the ambiguity left. Yes, Anamika, you are right. Ambiguity left on fact. What the fact is, whether the law and the intention of the legislature, you can say behind making this type of a schedule for will be followed or not. Why? Because not all the arbitration institution follows it. So it's very necessary now for the courts also, for the arbitral tribunals also, to allocate the cost in the accordance with the best of the international practices at that time. And to just eradicate the ambiguity, it's just like if a country want to just achieve the goal of becoming a prominent center for arbitration, then we have to just empower the court, just to decide to empower the courts also to speak up about the cost allocation, and just to ensure the enforcement of this provision. So that's with the provision of section number 31 of the Arbitration Act. I hope the concept is clear to you all. Yes, now one by one you can just ask me your queries. Except the Anamika, no one is here just who's responding to what I am asking or not. Good going, Anamika. Anyone want to ask anything about this? Another PDF is there also there. I will put that also on the screen. I think this is visible to you all. Yes, Anamika, you are just saying, can you please just explain once again the ambiguity part? Yes, the ambiguity part is just ambiguity part is just about what the first, for example, without the cost allocation, what would happen, and the whether the law and its intention are what intention of the legislature just to making the schedule 4 will be followed or not, because not all the arbitral tribunals are following it. And it's very important for the aspect also, no, for the present scenario also, that the courts and the arbitral tribunals are just like uh, wait for a second, my PC running battery running low. I'm just plugging it. Yes, and then it's just necessary also that the arbitral tribunal must allocate the cost with the best international practices and so on. So that's why we just need to eradicate the ambiguity part. And moreover, if our country want to be the global center for the arbitration, so the intentions of making the legislation must be followed. There must be no such discrepancies regarding the cost allocation and so on. Yes, anyone else want to ask anything, please? Anamika, I hope now you got the topic. Yes, Anamika, anytime. Here in this PDF also I am saying the same case like that of anyone else want to ask this, please come forward. Everything, the concept is clear to you all. The concept is clear to you all, then gives a thumbs up. No one is giving a thumbs up, no one is writing anything, no one is asking anything. Okay, no worries. I hope the concept is clear to you all. Okay, Ramika, yeah, I got you. You are here in the class. Yes, Akash. No, anyone want to ask anything else? We will wrap today's class and we'll meet you tomorrow with a new draft. I think no one have any question. Okay, if the legal Vidya is here, then please wrap the session, because there was no such drafting aspect was there today's session. We'll discuss a new draft tomorrow.
Sure, ma'am. Thank you so much for such a interesting session. And I request students to be kindly interactive in the class, because this is not a way to just come in the class and not be attentive, right?
Yeah, absolutely. Much needed. Just be interactive, no matter what.
So kindly make sure you ask your questions. If you
Yes,
don't ask, then how will you learn, right?
yes.
So kindly be active from the next session. And I again want to thank you, ma'am, for such a great session.
Thank
And
you.
thank you, everyone.
Good night. Stay safe. Happy learning.